My name is Linnell Hartway. I am the Executive Director of the Northern California Tribal Court Coalition. And the coalition is basically a forum and group of tribes in Northern California represented through their courts and their judges that seeks to help in the restoring of balance and provision of justice within the tribal communities in Northern California, regionally and elsewhere. This training this morning is part of a series that's made possible through grant funding from the Judicial Council of California, as well as the California Office of Emergency Services and its provision of grant funding through VOCA and the Office of Victims of Crime. And I think then we are going to move on and start with some video clips that we have for you.
In terms of some background and statistics, DV's been around a really long time, but it wasn't until the mid-90s that the National Domestic Violence Hotline was established. And I'm astounded every year I check to see the contacts that they get and the inquiries that they get, and it's now well over 500,000 just from 2 years ago. I checked again recently, and with COVID, it's actually gone up another 10%. The high-risk teams and lethality assessments that we'll be talking about briefly at the end, they've only been instituted in the past decade. But again, unfortunately, DV just continues to be on the rise. It's just going up and up. These numbers, as Javier Becerra indicated, they're staggering. And in terms of how often, and Jake, you can go to the next slide, how often they occur, every 9 seconds, there is an incident. 1 in 3 women experience violence in a lifetime. And in terms of American Indian and Native Alaskan, as you heard, 4 in 5. Vast majority of those are committed by non-Native perpetrator. When you have the presence of a gun, that increases the risk of homicide for women over 500%. And it's even higher if there's been a strangulation incident. We're going to be talking about a little bit about that. The risk of death for American Indian, Alaska Native is 10 times greater. So these are just the ones, quite frankly, that are being reported. And domestic violence is really one of those most chronically underreported crimes. And we'll talk about that in just a moment. So what I wanted to do before we actually move on is just sort of have you all think about, as it relates to a victim and the level of risk or danger. I'm going to put up just 4 items, and I want you to just rank them in your own minds. What concerns you the most in terms of, again, as it relates to the victim and level of risk? Is it that they own a gun, or that the perpetrator owns a gun, that there's alcoholism involved, that they've been estranged, recently broken up, or that there's been a suicide threat? So if you think about that, I pretty much could guarantee you that everybody is going to say that in terms of the highest level of danger or risk is going to be the gun. And you're right about that. So you can just push one more, just one. Next, if you're, again, what you're thinking, the next level of danger really for a victim is when the parties who have been either former dating, whether they're married, unmarried, with children, is breaking up, being estranged. At that point in a relationship is probably one of the most dangerous other than the gun. Next comes the suicide threat. I'm going to kill you. I'm going to kill myself. Again, this past studies have shown that these are times at which the risk and the danger with regard to the victim and children are highest, and last becomes the alcohol. So what I'd like to do is talk just a little bit about, and I want to ask Judge Abby too, oftentimes a person doesn't even recognize the danger, and there are some barriers with regard to that. There are cultural barriers why victims don't report. Why is it so underreported? One of the things that's very important to understand for law enforcement, and judges, advocates know this, in terms of being careful not to make any value judgments or assessments as to why somebody doesn't report. There can be a lot of reasons. economic reasons. There can be fear for the, their own safety of the children. There can be geographical distance. These are just general lack of available and appropriate resources. But for Native Americans, it's even greater. And I want Judge Abby to speak a little bit about that.
Well, I think we all know that one of the big challenges in our region is the region itself. We are so far away from help and from support. We have a history of difficult relationships with some of the agencies who we're now partnering with, and who I feel are also working with us to overcome some of the issues that happened that our people hold in their minds. And one of the things I learned from our chief, which I found was very interesting, he asked me one day, what is the Yurok word for police? And I said, I don't think I know. And then he told me, and I said, what's the translation? And he said, the translation of that word is men who steal children. Because our first introduction to them were when they came and they took children and forced them away from their parents, either through indentured slave or through boarding schools. And when you have that kind of history and that kind of negativity, it's hard to overcome. And people need to understand that. And they need to understand that as we're working to put these things together, we have a lot of obstacles to overcome. And I think also rural areas, not just reservations, are terrifically underfunded, so that when we need resources, it is a scramble to get them. So that when we're trying to get help for our victims and for the perpetrators, it's been a long time coming to be able to do these kinds of things. And we're working very hard with our partners to try to stem the tide and to say, no more, no more. But you have these things to overcome. And one of the things that I want to make sure that people realize is that we are partnering with the different law enforcement agencies, but I want to make it really clear that the other agencies, although we're offering their ability, them the ability to call us for us to issue EPOs, that when they do that, as opposed to when they call a superior court judge, is really a decision, a policy decision that is going to be made internally in their agencies. We are going to be available for some of this help to assist the law enforcement agencies that we work with, but it, generally speaking, is going to be the call of their department when and who to call. But what we want to emphasize is somebody is going to be called. We're all done with this. We don't want to live like this in our shared communities.
And I actually recommend for everybody, not that, if for reading in terms of really truly understanding domestic violence and what it can do and how it even looks, because there is no one look to it for individuals and families, and what a victim is going through during this whole process is the book No Visible Bruises. What we don't know about domestic violence can kill us. I put a quote in it, and I only recently, I've been training bench officers here in San Francisco for many years, and this book came out. I read it a couple of years ago, and I was just struck. They studied a number of cases where there was lethality involved, and trying to say, well, how is it that we didn't see it? And I would encourage it if you have the opportunity.
So the first slide, I just wanted to sort of touch upon the types of protective orders that law enforcement are going to see. And these are from non-tribal court jurisdictions. So we have emergency protective orders, we have ex parte restraining orders, and then there are what are called order after hearing. So for our orders to become more than just a temporary restraining order, there has to actually be a hearing where witnesses testify, and then ultimately there's a OAH issued. If we file criminal charges, we have two options for restraining orders. We can get one pending trial, and then after the case is completed and the person's convicted, we have the ability to then seek a protective order that requires the restrained person to stay away from the victim. With regards to the enforcement of these protection orders, I cited the California Family Code sections. The order is valid when we can show the restraining order or the protective order identifies the protective individual and the respondent, that it's currently in effect, so it has to be still valid. And this is something we ask sometimes when law enforcement calls us from the scene and says, we're here, we're looking at the order, but I don't see a date on it. We'll go through with them and discuss where are the dates, is it still valid? That the issuing tribunal had jurisdiction over the parties, and then that the respondent was given reasonable notice and had the opportunity to be heard before the order was issued, or will have the opportunity to be heard within a reasonable time after the order. And then the last one, which is kind of critical, is that the respondent has been notified or served with the order. And I say that because sometimes, even though the individual was noticed of the hearing date and the person who's seeking the restraining order is in court and presents the information to the judge, and the judge issues that order, we then need to know that the person that has to stay away has somehow been noticed.
So sometimes we know that when we respond to violations or restraining orders or complaints, that there is a defense that the person didn't know about the restraining order or they weren't properly served, right? And so that's a part of our elements of our crime, making sure that they knew about it. So, when the notice of proof of service cannot be verified, number one, we can do that service as law enforcement. We can provide that service a notice. We would see it as a face value, a valid restraining order. We can put that person on notice that this is a valid restraining order. Inform the restrained person of the terms of the order, detail by detail, reading it to them is totally something that law enforcement could do. We can make a reasonable effort to serve that order, allow the person the opportunity to comply with the order. Once they know and it's verified that we went through it and they understand it, then give them the opportunity to comply with that order. And again, what are the consequences of that? If they do not comply or if they violate that restraining order, then they could be subject to arrest. Now, over the last, especially the last year, we've been kind of hamstrung with our pandemic guidelines in the jail, but our jail is open for service. And so we are even taking misdemeanors that are problems in our community. They still have the option to cite and release for violation of the court order, but we can book those people in our county jail for violation of a court order or a restraining order. And so we understand that sometimes that is very necessary for someone who is harassing someone who does not want to comply with the restraining order. And it's our way of separating and holding that person accountable. And then they also have the opportunity, if their likelihood to reoccur, to hold that person in custody until they are arraigned. So that's it. Then once we do that documented service, we do have to write a report to document that and to send that to the court as our proof of service. So that's kind of a little bit about proof of service.
Sometimes there's conflicting orders, so we always like to let law enforcement officers in the field know, verify the validity of all the orders. If they're conflicting orders of the same type, so either both are from civil court or both from criminal court, the most recent order takes precedent. But the most important part is that the most restrictive terms take precedence over conflicting orders. And this comes up quite a bit because maybe in family law, that judge issued sort of a limited restraining order, but then once we have a conviction, for example, in domestic violence, we have a much more extensive restraining order. Literally they can't go to the school, perhaps they can't go, other places where they might run into the party who's afraid of them. And so that's what we always want to remind people is the most restrictive terms are what we enforce.
Right. It's important, I think, in law enforcement to prove these cases beyond a reasonable doubt. We need to document all the elements of the crime. And number one, that they did know about the violation, they did know the restraining order, they did know that by their action violated the restraining order, and making sure that we collect that evidence that is necessary to prove this case, so the district attorney can then prove their case in court. So it's our job in law enforcement to make sure that we do get the required paperwork, and a certified copy is better. But we don't need a certified copy to make the arrest, but to prove in court, we definitely do need that, and to provide witness statements. And even if we respond to the scene, and we know with domestic violence, sometimes we do have people that don't want to prosecute because of fear of retaliation. We can make those arrests, and we encourage our law enforcement officers to make those arrests when they do become aware that someone is violating a restraining order, whether it's, from elder abuse, domestic violence. We understand there's a lot of intimidation that's going on out there, and so we encourage our law enforcement officers to make that arrest, and so that protected person is truly protected, and then advocates can come in and do their part. So.
And that was what we wanted to cover, and thank you for giving us the opportunity to do that.
So the videos series that we provided shows some of our prior discussions and some background information about issues regarding the enforcement of protection orders in California that have been issued by tribal courts, some of the efforts that have been previously made in order to address those issues, and the processes by which those orders can be enforced or are being enforced through different agencies and tribes. This morning, we now have live for us, starting out some conversations regarding current efforts of enforcement and issues. We are going to start with Judge Blake. Judge Blake is the Chief Judge at Hoopa Valley Tribe, as well as other tribal courts within the region. I believe most of you are familiar with Judge Blake. And he is going to start us off in a conversation about some additional efforts that are being made, as well as some new developments in the state of California. For those of you who are participating, we have some time for Q&A on our agenda. So feel free to chat in any questions that you have, and we will reserve time at the end as well to take both the chatted in questions as well as any questions that you want to add verbally. Thank you, and welcome, Judge Blake.
Thank you. And on behalf of the Northern California Tribal Court Coalition, welcome each and every one of you for participating today. I thank you, Linnell, for the kind words. As I sat and listened to this today, the coalition is, it's celebrating, I think, pretty close to 15 years in existence. And as I thought about this when I was preparing for this today, I was realizing that our issues kind of remain the same. But I will tell you that as I was previously the president of the National American Indian Court Judges Association, and this is not something that's uncommon across the nation. But I will say that in Humboldt County, we are very, very blessed because, one, we have a district attorney's office that is very open to working with us. We have a sheriff who is also, very, very open door when issues come up. And if something comes up, always about finding a solution to trying to fix a problem, especially when it surrounds protection of community members within the boundaries of the Hoopa Valley Indian Reservation. And as Linnell had explained, I also sit as Chief Judge for the Redding Rancheria and sit as the associate at the Tolowa Nation in Smith River. So this is repeated across our country. Across Northern California, and something that has not really been completely addressed. But one of the things years ago when we started that we had continued to ask for is a domestic violence protection order that was issued by a tribe, sometimes met with some resistance, not by complete ignorance or by just blatant disregard. Sometimes it came out of confusion. And I heard Sheriff Honsal's quote in the vignette that was provided, that there has to be a way to confirm that there is an actual protection order, and I 100% agree with that. That there is the need to determine that there is an active domestic violence protection order in place for enforcement to occur. The Northern California Tribal Court Coalition, when we realized that there was problems with the protection orders, we made a lot of advancement in protection orders by trying to do several things. One, we tried to mirror what the tribal and state court protection orders look like. And we call it, I guess, a squint test. If it kind of looks like a protection order, perhaps a law enforcement officer on the street would look at that and recognize that it was a protection order and that it should be given full faith and credit. But with the findings that are included, embedded in our protection orders, they are protected by federal law and under the Violence Against Women's Act. So we make certain that we include all those findings to have a sound domestic violence protection order. And if there are any changes, typically what we will do in Hoopa is we will reach out to the sheriff's department and make certain that we are keeping them abreast of any changes that we have in our protection orders, and or if there are problem areas that we are experiencing, that we are sharing that with them and letting them help us find a solution to that. A big problem that we have had previously, and I'm not quite certain that it has ever been resolved, is, and I think that with across the counties in California, the manner in which a domestic violence protection order is issued into a system once it's issued by a tribal court. Presently, the Hoopa Valley Tribe was the first to develop this protocol with the protection order registry, and that required working with the sheriff's department and working with the courts to get a protection order filed under with a DV 600, which is an out-of-state recognition of out-of-state order. And ironically enough, I mean, California surrounds tribal communities, and we are well within the California structure, but it was a fix. It was a fix to try to, so that we are able to get our orders into the system. Ironically, on October 10th, 2023, Mary Kiefer Lopez with the AG's office sent out a memo, and the Assembly Member Ramos introduced Assembly Bill 44, which proposed access to the CLETS, the CLET system in California for tribal law enforcement and courts. And this has been something that's been asked for years. And when I say asked for years, I had previously used this system and was wondering why it was that tribes weren't allowed to use this. And there was a lot of question about and some opposition to tribes having access to this. And we have through the California Tribal State Forum, we tried to address this with the prior Attorney General Harris. We tried meeting with her on numerous occasions to try to get this issue resolved, but it was never done. I mean, we would schedule meetings, and unfortunately, she would fail to appear. We would meet with her people, but we needed her to do exactly what has happened, which is to support this effort. The Yurok tribe and the Yurok tribe spearheaded this. The Yurok tribe approached Ramos and asked him if he would support this assembly bill. He did so. So it took a tribe stepping forward to say that is this important. And one that I will say that not only the coalition, but the California Tribal State Forum has also addressed consistently for the past 10 plus years, trying to make this a possibility for tribes. This is going to create a lot of shortcuts for the court to get our protection orders into the system. And in other ways, being able to support the victims of domestic violence when we are able to verify that there are actual restraining orders, and or that we can find help find our the victims of domestic violence. I have one of the things I wanted to say thank you to Mary Kiefer Lopez for the information. One, it was well received because, like I said, a long time in coming. And when I looked back at this, I think it's well over 10 years that we've been doing this. And I don't know that there is a 100% fix to the registration of domestic violence protection orders, but this is certainly a step in the right direction in this cause. As I was talking with Linnell the other day, it was so exciting to me that I sent it out just to about everybody I knew in my friends list because it was that exciting for me. It just it's been a long time in coming. There's a lot of it's not going to happen overnight. I understand there has to be some resolutions developed with the tribes and the state to be able to access this. And additionally, we also have some training to do and understanding that they're finding the dedicated people to operate the system so that we are remaining in compliance with what the state is asking us for access to this terminal. As I said, as soon as it was announced, I started my plan, and we have our in-house counsel meeting with our domestic violence advocate and with the Office of Tribal Attorney to get this resolution signed so that we can get that to the state so that we are able to move forward as quickly as possible with this process. Other than I am willing to share this memo. If you guys have not seen it, I'm certain that everybody has probably seen it already. But if you haven't, please let Linnell know or Georgie know, and we'll make certain that we get a copy of it posted to our website so that you can view that. Again, great day in Indian country for this assembly bill that will again provide protection to the victims of violence in our tribal communities. Ms. Linnell, that's about what I have this morning. I know I was on pretty limited time. Anything that you have additionally?
Well, you do have plenty of time left. So I think we can open it up if you didn't have anything else prepared. If there are any questions from the audience in terms of Judge Blake or the process. And just to start us off, I would say, if you could just, I think, give a little background to the group as well as our participants about some of the issues that you have had with the enforcement across just personal experiences or that can highlight the efforts that are needed in order to provide solutions.
Certainly. So, one of the biggest things that ever comes to mind is that in my community, it's when you live in Hoopa, everyone knows where you live. And when I say everyone, it wasn't uncommon for somebody who, who had a case pending would stop by to tell me, hey, I missed court today. Well, you can't do that because that's ex parte. But I see Michelle's on here. Michelle and I constantly had that battle with folks is that you can't do that. But I had a case where I issued a protection order for a woman, and I will say to the current sheriff, this is way before he was even the elected sheriff. So I will say we have grown milestones since this point, but it is an issue that happened in Humboldt County. So I had issued this order for this lady. She was beyond ecstatic because she got her order of protection and felt that she was going to be protected from any threats of violence and or violence. The lady, so I issued the order, she leaves, and later that night, I lived right along the road, and it was probably about 10:30, 11 o'clock at night. I had a knock on my sliding glass door, and I looked out the curtain, and there was my litigant, my protected victim, standing outside my door in the rain, all bloodied. And I opened the door, and I was like, what are you doing? And she said, the order's no good. And I said, pardon me? She goes, the order is no good. And I said, no, it is good. And she said, no, the deputy sheriff said that it's not a valid order because it's not issued by the state. I brought her into my house. We cleaned her up, and she voiced her concern about how she felt that, it was just a complete waste of time for her to come through the tribal court if the orders were not going to be enforceable. It took a lot for her to come to the court system to get this protection order. It was even harder for me to explain to her that it was an error and that I would get it corrected. But how do you tell somebody who's sitting there bloodied after she has the feeling that she is getting a protection order? I constantly remind people that protection orders are a piece of paper, one that has to be cooperated with by both parties. And, protection orders don't prevent 100% of violence from occurring, and definitely don't stop bullets. So we definitely need to be mindful that protection orders require the cooperation of, both parties. But she walked away from my home. She didn't, I offered to get her a ride. She did not want to. That conversation that night, as she walked away, spurred what I say is the development of my taking this issue even further. I had reached out to the sheriff at that point and was very, very upset, one, that the resident deputy felt that it was okay to, one, criticize the protection order, and to peruse and to give legal opinion on whether or not that it was a valid order. The sheriff at that point did indicate that he was willing to address that with his staff, and we did some in-house training with them on tribal protection orders. But it went bigger from there. What we did from there is it became obvious that if it happens in Humboldt County, it has to be happening all across the state. So at that point, what I did was reached out to the Chief Justice in the state of California, and I told the Chief Justice, "Hey, we got a problem. I mean, the problem is one, victims of crime in my community are not being afforded the protection under tribal protection orders as allowed by federal law." The Chief Justice actually met with us, and that's how the California Tribal State Forum became an actual forum in the Judicial Council. It is we have the Northern California Tribal Court Coalition that addresses issues on a regional basis, and we work with one another judicially. We resources, all of the above, and we have dedicated staff that continue our mission, the mission of the coalition. But the forum addresses issues such as that issue that I just explained on a statewide basis. And I will tell you that Humboldt County became the milestone with both Hoopa and Yurok working with Humboldt County District Attorney and Sheriff's Department on developing a protocol that is going to provide for protections in our tribal communities. Currently, I will say I have a 100% respect for our sheriff. He's done a phenomenal job with working and with the court systems, the tribal court systems, as well as the Humboldt County Superior Court bench. We work jointly in joint jurisdiction arenas with the state court benches, and it has opened up relationships that one probably would never see would see in California had it not been for the ongoing efforts by both tribes and the county and state to find solutions to these problems. We have a lot of things that we could continue to work on, and I'm sure we will. And I wanted to say, the returning to Hoopa in 2022, the ongoing efforts that I have to doing this is even tenfold. And like I said, I have had a couple of meetings with the sheriff's administration, and any issue that comes up are dealt with immediately. So I think that collaboration between the agencies has been very beneficial to the membership of the Hoopa Valley Tribe as well as the Yurok Tribe. I do know that the relationship in Delaware County with the sheriff there is a little different, and there's ongoing issues with getting registration of protection orders. But as indicated previously, hopefully with this CLETS protocol, I mean this AB 44, we'll be able to develop a system that is going to be a little bit more streamlined, and it'll benefit all the state and tribes in its efforts to provide protection across the communities.
Thank you. I believe Sierra Parker is here and joining us today, and I believe she has the next question.
You're on mute.
There we go. Now can you hear me?
Yes.
Great. Hi, Judge Blake.
Hi.
I have a question that's come up for me with clients before, and I just want to clarify. So if someone receives a protective order through Hoopa Valley Tribal Court, should they file to register their order through Humboldt Superior Court as a precautionary measure, or is it pretty much guaranteed that the tribal court will automatically go through the process to register the order through state court?
So that is currently the protocol. Is what we do is once the order is issued, we do it with a domestic violence 600 form that is attached to it, and that is sent immediately to the county. So it is already registered with, and that gives the once signed by the state, and it's not even a signature. It's one that allows for the registration of the order, and then it's kicked up to the sheriff's department and put it into the system for so that it hits the data systems, and they know that there is an active warrant out. I mean, active protection order. I'm sorry.
Thank you.
You're welcome. And it's interesting because not all, I mean, people don't understand that at this point, if the tribal courts are doing are issuing protection orders, if that's something they are doing, it is a protocol that has been established with each county. And I will tell you that I haven't heard of one county, I mean, 2 counties doing it the same. And like I say, I think that the protocols that have been outlined in Humboldt have been used across the state, and it shows. I mean, the sheriff in the Humboldt County bench has the bragging rights that they have, more tribes, locally that they work with, that gives them the ability to have the leading edge on this information. So we are we're a good testing ground for all of these protocols to be developed, and like I said before, we couldn't have better partners.
Looks like we have a question. Michelle.
Hi, Judge Blake.
Hey, Michelle.
Would you go over just really quickly what happens when one party files in tribal court and one party files in state court? Because I see this coming up more and more, where someone gets a protective order in one jurisdiction, and then the other party goes to the other jurisdiction and gets a protective order, and then you can have these dueling protective orders.
Oh my goodness, a race to the courthouse, they call it. So typically what happens is if there is joint filings that happen, what we typically do is we look at the court of first filing, meaning that if it is filed in the Humboldt County Superior Court first, then the matter will stay in Humboldt County. If it is filed in Hoopa, then we keep it. But there have been cases where parties don't usually agree that it's been that the court selected is actually the court of first filing. So then through the California Tribal State Forum and the dialogue that we've had with our state court counterparts, it was decided that what we would do is we would do a jurisdiction call, meaning that the Hoopa Valley bench would reach out to the Humboldt County Superior Court bench that was hearing that, and we would discuss which court we felt would be more suitable to handle this. And as I will say that neither of us are fighting for work, so it's not a battle that we feel ownership to it. It's that we want to make certain that we are following the court of first filing. And it may also be that it is that there are resources that the Hoopa Valley Tribe and or the Humboldt County Superior Court may not be able to provide for these litigants, and it may be decided based on that. If there is a DV program that one of the batterer can get into quicker, then it may be determined that that is the venue where the parties should be. Typically, once decided, the parties don't usually dispute the findings, and then once accepted, then the other jurisdiction will typically dismiss. And quite honestly, I've had some very, very meaningful communications with my state court counterparts in deciding these jurisdiction issues. And like I said, nobody fights for them. I mean, meaning that as long as the protection that is being sought is being addressed, I think that we're both comfortable that we're both capable of addressing and handling the domestic violence cases.
Michelle, I saw your hand up again. Did you have more?
No, I actually just hadn't taken it down.
So honestly, Michelle could probably be a presenter here as well, because Michelle says my associate at Hoopa for 10 plus years or more, probably 15 years, and issued a lot of these protection orders and saw was witness to the obstacles that we constantly battled. And the other concern is that people are also of the belief that, oh my gosh, if I file a protection order, I can never file again. The national stats show that victims of violence typically take more than 1, 2, 3, or 4 times to file a protection order, and before they really want it to stay in place, either out of fear, or that they need someone to pay the bills in the house, and or for they consider the best interest of their family. So there's a lot of reasons that people don't follow through with protection orders. But the myth that, if you filed 4 or 5 times, that you're not going to get it. No, I think that every court is well aware that that does occur, and one that when I see it for the 4th or 5th time, and I'm thinking maybe this will be the time. And with that type of attitude, I don't want a victim to think that because she or he has filed previously, that the court is going to frown upon them filing yet again, even if they do return. Ultimately, I think that in most cases, except for an extreme abuse, and the possibility of reunification is likely. And if addressed and they are able to resolve all of that, the court is not of the ability to prevent anyone from having a relationship.
Looks like we have a question in the chat from Vicky Bates. This question says, I am being told by officers that the person being protected with the restraining order needs to keep the order with them at all times. Sometimes the person cannot take anything with them, let alone a pack of paper. Is this something I need to tell clients?
Yikes. And Sheriff Honsal, you might want to help me out with this one, my friend. So, it is always probably advisable that if you do have the ability to carry, it would be great because, sometimes radio communication, there's a lot of reasons why somebody may not have that, but I have never been the boots on the ground like Sheriff Honsal, so that a protection order in the out in the field, having that copy certainly would make things easier. But I know that I don't know the protocol that is used once it's been issued, and that is something I think that the sheriff might be able to answer more clearly on what the deputy is looking and whether that is something that is required at contact with law enforcement. Sheriff, I'll defer to you, sir.
Judge Blake, I appreciate that, and always good working with you. And I appreciate all your words and our teamwork that we have. So, getting back to the question is, we always, when we're out in the field and we get called to a restraining order violation, we want to be able to see the restraining order. Sometimes they're in the system in a tribal court order, and I can explain later about tribal court orders and what we experience, but we actually need to see those orders. And this could be as easy as someone taking a picture of the order and having the picture on their phone. That is something that's easily done, because what we're going to want to do is we're going to want to provide the evidence to the responding officer that an order does exist. And if it's not in the system, the computer system that we normally check, then what we want to do is see a hard copy. And sometimes if the courts are still open, we can call the courts and they can verify that this is a valid restraining order. But just to have a valid signed copy of the restraining order or on your phone, it is something that we can use and we can enforce. And that's something that we do see out in the field, and that's something that we do that we do encourage our victims of domestic violence is to have that. And so I hope that answers your question.
Thank you, Sheriff.
That is great to hear. Thank you, Sheriff. Summer, do you have a question?
I do. And thank you, Sheriff, for saying take a picture, because that's something that I have never thought of telling our clients to do. Sometimes the packets are lengthy. Is there a particular page that they need to take a picture to kind of fast track that? Or do you recommend them taking a picture of every single page of the packet?
Yeah, I would recommend they take a picture of every single page, and that would be the ideal scenario, because we can say that we acted on good faith, that we saw every information on that and we acted accordingly, because there are some things in each of those pages that are relevant when it comes to the restraining order, as far as who is to be protected and who is to be served, whether it was good service, the distance where they should stay away from the protected party, and then also staying away from different locations, whether that's a business, residence, whether that's a school. All those things are a part of the whole packet. And then the signature, the signed by a judge, in what court, the authority, as well as good service.
Thank you.
I agree, Sheriff. I had never thought of the picture of the order on the phone, and it is something that I will utilize from now on, sir. And I will tell you, I will tell everybody I thought of that. So if you hear
Perfect.
that, that I thought of that, mum's a word.
Absolutely. All good.
We have another question in the chat here from Michelle. The other issue that comes up with restraining orders is whether or not they have been served. Do you have any advice for how victims can prove the restraining order was served on the restrained person if it is a tribal order and not entered into CLETS?
Well, I can chime in on that if that's okay, Judge Blake.
Sure, please.
A couple different things. It's easiest when the service does occur within the court system, but we understand that when oftentimes perpetrators don't want to show up to court, and so we have to go out and we have to seek service. And any law enforcement officer or any person can serve the restrained party. We just have to prove that. And the one thing is with tribal court orders is we have to act on good faith. And so if someone proves service on the back of a napkin, even, which is sometimes, why would you do that? Well, in tribal court orders, we can do this. Say, on such a day, such as a time, I serve the following, protected order on this person, and with a signed signature, and with the court report number or restraining order number on it. That would be good to go. That's evidence that we could use to say that this person has been served, and we can act in good faith that would happen. But any law enforcement officer can serve. So let's just say that there is a valid restraining order out there. It just needs service. The person is harassing you or has come near you, and law enforcement comes and they go, okay, we don't have proof of service. At this point in time, we can tell the perpetrator, said, suspect, you have a restraining order against you. I'm going to give you the details of the restraining order and provide them all the details regarding date and time the service was, or the order was issued, all the details of the restraining order. And then if we have the ability to provide a copy to the person, we could do that as well. But oftentimes we're just going to verbally say, you have a restraining order. This is the court it's out of. These are the restrictions of the restraining order. And you need to stay away from the protected party. You need to stay away from the address or whatever the details are, and tell them that they have been served, and give them the opportunity now to take that information and to distance themselves and not come around the protected party. If the person then turns around and violates that restraining order, then we can immediately act upon it. There doesn't need to be a day. It doesn't need to be a certain time. If the person refuses to leave at that point in time, he's been served notice, he understands it, and we can act on it.
And I agree with everything the sheriff said on that. Thanks for the question, Michelle.
We are scheduled on our agenda for next to take a short break. We have another hour for our webinar and training. And coming up next, we are going to have Sheriff Honsal present his information as scheduled. And then we have some tribally focused service providers present to talk about their issues with enforcement of protection orders and other information. So thank you, Judge Blake, very much for your time. Of course, we would be thrilled to have you continue if you are able. I'm sure that you are have much information that can help us all out, but understand that you are busy. So I want to thank you for your time. And it is now 11 o'clock, and so we will be jumping back on in 10 minutes. So we will see you at 11:10. Hello, everyone. It is 11:10. For those of you who are off getting coffee or multitasking, if you can rejoin us back at our discussion, we are ready to move on to our next item on our agenda for our training on enforcement of tribal protection orders in California. And we are pleased to have with us, as he spoke earlier, Sheriff Honsal, to talk a little bit about law enforcement and bulletin or updates, and also issues that he can share regarding enforcement of tribal protection orders and improving the process. So thank you for joining us, Sheriff, and please go ahead.
Thank you very much for having me. I really appreciate it. Chief Greg O'Rourke was supposed to be here with me today, but he is under the weather. And so I will be, I'll be trying to speak on his behalf as well. You know, Judge Blake said it perfectly. You know, there's been a lot of improvements over the last 70 years. If you can believe it's been 70 years since Public Law 280 has been essentially forced upon the tribal communities here in California and law enforcement. And the federal government made this ruling without any providing really any true guidance. And so over the last 70 years, tribal governments, sovereign governments have been trying to establish themselves. And I think we're making significant progress over the last several years. And I'm very, very proud to say that that we enjoy our working relationship here in Humboldt County. And like Judge Blake said, I think we're the model throughout the state with how we are working within existing law and trying to do things according to the law and the spirit of the law. And it doesn't mean that it's not that it's perfect. We are far from perfect, and there's things that we need to improve upon every day. But one of our primary goals and function is to protect victims, witnesses, and survivors of the crimes here, and be able to have an avenue for people to advocate for themselves, to report crimes, and to have tribal courts and law enforcement stand up for them when they do decide that they will no longer be victims of crime. So that's one of our chief priorities, is to protect victims and to have a process of the law, provide that due process, as well as follow the orders of the court, enforce the law, and to take action where necessary. And that's part of our job. And when we take action, it's documented action, and sometimes it's a referral to different agencies that can assist. But we can't do that without the teamwork. We can't do that without the trust of our communities. And that is something that we're going to continuously work on, that we can't just take advantage of the trust we have. We have to continuously establish that trust every day. And that's one thing that we're going to do. One thing that Judge Blake did mention is AB 44. AB 44 passed this last week. It's signed by the governor. It is going to be a game changer for the tribal communities, because as of right now, you know, like Judge Blake said, and it was referred to, that there's a huge process. When you get a tribal court restraining order, it essentially has to be hand walked or emailed or transferred over to state superior court for them to enter this into their systems. And sometimes it takes days for that to happen. And without having someone have that paper copy, sometimes it's hard to prove that a tribal court order exists or a court order exists. And that doesn't establish any kind of faith within the court system or law enforcement. So by having CLETS access by the tribal government, it's going to be huge. And so we're definitely looking forward to that implementation and working together. So pretty great on that. So tribal protection orders, they are being issued here in our county, but also throughout the state. Tribal courts are being established throughout the state. And so the law basically says that any tribal court protection order is good. It's good to be enforced wherever it is, not on just tribal land, but everywhere throughout the state. So a tribal protection order issued in Los Angeles can be enforced here in Humboldt County, in the city of Eureka. And that every officer has to take action and to look at these with full faith and credit is what the law says, which basically means that if you see it there and it's an order, then you shall act upon that order. And domestic violence is one of those things that if we have probable cause to know that a restraining order has been violated, that the officer can act. We don't need the victim to actually press charges. If there's a domestic violence restraining order that's valid, and we know that the perpetrator is violating that order, we can take action and we can arrest that person. and we can transport them, book them in our jail. And though it's only a misdemeanor, you know, we can hold this person in custody unless they want to bail out, you know, until a judge does see them. So that is something that can happen. So we definitely want to take that enforcement action, but excuse me. But what we really want to do is tell the people that are seeking these restraining orders to make sure they do have a copy in play, to not just rely on our CLES system. That's the California Law Enforcement Telecommunications System. Don't just rely upon that. Have that hard copy available. Take a picture of it so they can prove that they have a restraining order. And we talked about good service, and we talked about making sure that you know, that people do call us. Okay, when there is a violation of the restraining order, please, if you're in a safe place, call us. If you need to get to a safe place before you call us, please do that. But as soon as you can, call and make that report. One thing we don't want to make a mistake is sometimes with perpetrators, they get our victims to kind of compromise on the restraining orders. And then once the compromise happens, I say, hey, let's just meet at a park. I just want to talk to you about something and that kind of thing. And our survivors, the people that get their restraining orders, they go and they meet someone there. And though it may be amicable at first, then it goes sideways. And now the person that sought the restraining order, you know, thinks, okay, well, I'm the one that kind of caused this to come together. I agreed to meet this person. It doesn't matter. It doesn't matter. Call us anyway. It doesn't give that person a right to threaten, to perpetrate violence against the person that sought the restraining order. So please, just because there may be a compromise doesn't mean that the restraining order isn't valid still. So please call us. We can act on it. And so that's something that we definitely want to come across. We recognize that there may be different formats, and with tribal court orders, they may not be in the same format as in state court, though we try and make them duplicate it. You know, I know our tribal courts are really good up here, but there may be a tribal court somewhere else around the state that doesn't look the same. And that doesn't matter. It doesn't matter. In state court or in state law basically says that we're supposed to look at that the same way. That's why when I talked about earlier about proof of service and then on the back of a napkin kind of a thing, yeah, I mean, that would be a valid proof of service as far as tribal restraining orders are concerned. So, you know, one thing that we're trying to consistently do is educate. And with law enforcement, we are really regimented with how things looked, how things are supposed to you know, everything is sometimes in the laws, obviously black and white, and there's certain procedures that are pretty black and white as far as how we're supposed to handle them. And then sometimes, like I said, the tribal court orders, because it's a mix between, you know, tribal courts that are just getting off the ground and trying to do their best, and maybe they don't have all the tools necessary, and so sometimes law enforcement misses it. And so it's okay if if you are not receiving the service that you think you should be receiving, and that a deputy or an officer isn't taking this seriously, that you call and ask for a supervisor. And ask for a supervisor and a sergeant, the watch commander. All those people can come in and hopefully lend some you know, shed some light on this to the officer, because we have officers now. I mean, over half the department now has less than 3 years experience, and so I wish it was different, but we have a lot of turnover as far as law enforcement goes, and you know, so we don't have a whole lot of experience. So it's okay to ask for a supervisor. You're not being disrespectful. You just want to be able to educate them. All of our deputies should know, and it's part of our field training program. It's part of our policy that they will enforce tribal protection orders. So that is definitely a must. You know, it's talked about too. You don't need a certified copy. You know, in superior court, oftentimes you'll need a certified stamp copy of those kind of things, other protection order. That's not necessary when it comes to tribal court orders. And you don't have to file those with the court. It just everything that you can have from the court that says you have a restraining order and that it's good proof of service and it's signed by a judge. That's all that's necessary for us to be able to enforce that. So let me see. I'll check my notes here. So it's going to be the priority of law enforcement to basically enforce all of these orders. And whether it's an emergency protective order, whether it's a domestic violence restraining order, whether it's a custody order, a stay away order, whatever it is, it's going to be our priority to enforce those orders. And sometimes there are some conflicting orders that come that do take place. And you know, what we want to do is we want to take the most recent order, most restrictive order. That's a fair advice that we give our people, that we will enforce the most you know, the most restrictive that way. And we just feel like we're there to protect the persons that sought these restraining orders. And so if there's a conflict there, then we're going to let the courts figure it out. But in the meantime, we're going to keep distance between the parties, and we're going to make sure that does take place. We understand that there are continuously going to be challenges in law enforcement. This is law enforcement throughout the state. There's 58 counties. Not all counties have tribal lands within their jurisdiction, but tribal court orders are valid in all 58 counties. And so one thing that we're going to do is continue to educate throughout the state of California. I'm the tribal liaison for the State Sheriff's Association. I work closely with the Department of Justice, as well as the legislature when it comes to tribal affairs. And so we're going to do our best to educate all law enforcement when it comes to restraining orders and enforcing of state law on tribal land. Let's see here. I think we covered service earlier, so I don't have to touch on that. But basically, that's all that I have prepared for today. And I'm definitely open for any questions that anyone might have about the restraining order process, law enforcement of it. And so I'm definitely here available for you guys.
Thank you, Sheriff Honsal. It looks like we have a question in the chat from Vicki Bates. What will happen if a victim or survivor does not have a copy or picture of the order and it's a weekend and or nighttime? When contacting the agency who wrote the order is not available, will the person be protected, or what would be the process?
So we have to rely on evidence to show that there is a restraining order in play. And so what we will do is we will respond, and if we can't prove what the specifics are on this, and again, it could just be, you know, a copy of it, or like I said, a picture of it, some way of confirming that there is a restraining order in place and what those restrictions are. We can't necessarily enforce that, but what we can do is we can tell the person that that is the potential perpetrator of this crime that there may be a restraining order and that they need to stay away from this person. If they don't, they could be in violation. In the meantime, we'll do our best to try and track down that information. We can contact the judge after hours at times. Judge Blake is oftentimes woken up in the middle of the night, you know, trying to get information from a case. As well as our Superior Court judges. And so whatever we can do to try and confirm that that does happen, we will do that. But it is, again, it's if you have a restraining order, it is imperative that you have some kind of copy or documentation of what the specifics are of the order, so law enforcement can enforce it. They can enforce it.
Thank you. And first, we had a question from the chat. Do those trainings get offered to tribal police?
Yes, tribal police are definitely they are accustomed to working with tribal court, and a lot of the cases that they generate will go right to tribal court. These are the civil and regulatory issues that occur on tribal land. So they're definitely familiar with it, and they're familiar with the process. The deputized tribal officers are for sure up to speed on the process and how we can enforce that.
And Sheriff, if you could please explain the cross deputization. Essentially, those are your deputies. Is that not correct? And so so those trainings would be offered to those people that are under your command.
Yes, thank you, Judge Blake. So as of the state law is right now, the only way for tribal police to enforce state law on tribal land is that they have a deputization agreement through their sheriff's office. And there's a part of the penal code that allows me to provide that authority to tribal officers. They are essentially reserve deputy sheriffs. They still maintain that they are employed by the tribe. They still have all the tribal police officer powers, and some even have the Special Law Enforcement Commission, which is federal peace officer powers and state peace officer powers. So you think about it, they have the trifecta here. They have state peace officer powers, federal law enforcement officer powers, as well as tribal police officer powers. And they can enforce all of those regulations on tribal land. So it is a great thing for us to have that here in the county. As of right now, we have 3 tribal law enforcement agencies that have that deputization agreement: Hoopa, Yurok, and Blue Lake.
Thank you, Sheriff Honsal and Judge Blake. Michelle?
Hi, Sheriff Honsal. I have 2 questions that aren't really related, but hopefully you'll be able to answer. I think you'll be able to answer both of them. One is, could you just give a brief overview of when your deputies go out, if someone wants an emergency protective order, if they want your deputy to contact a judge, do they need to request that, or will your deputies do it automatically? And then the second completely unrelated question is, do you ever do training with the other law enforcement agencies, or the local agencies, or would you be willing to? Because I know I had a case where about a year ago, an EPD officer told a client that tribal court orders weren't enforceable, but in Eureka, and that's not on you, that's not your agency at all.
Right.
But I was just wondering, is there any kind of forum where you would be able to kind of reach out to some of the other agencies just to make sure they have the same knowledge that your officers have, your deputies have?
Yes, for sure. You know, the Department of Justice has taken lots of lengths to try and educate all law enforcement. They put out a bulletin last year that essentially was sent out to all law enforcement that outlines the restraining order process for enforcement of restraining order process for tribal court orders. And so it's a really, really well written training bulletin. And so, Michelle, by bringing this up, I thought that all law enforcement, I actually brought it up to our chief's meeting, and I thought that all law enforcement was trained and educated on this. I will go ahead and send it back out to all the law enforcement agencies in the county, just as a refresher. And so they understand the ins and outs of the Department of Justice here. I saw Keith Altizer, who is a Arcata Police Sergeant, and he's on this call right now. I know he'll bring it back to the Arcata Police Department, and I'll make sure that he has this latest information bulletin if he doesn't have it. But it's definitely something that we want to consistently educate our law enforcement. Definitely.
And then just if you could go over real quick the EPO process for, does a victim need to request one, or do your officers automatically grant it? Because I know people I've worked with have been really confused about that.
Yes, if we respond to a scene where there is a need for emergency protective order, so someone is a victim of domestic violence, and we can see that they, are fearing for their safety, and we make an arrest on this subject. we are required by law to ask, say, do you want an emergency protective order? At that point in time, they can say yes or no. If they say yes, then we'll call an on-call judge, and we will get that order. We will run that order by the judge. It'll be up to the judge to approve that order. Essentially, the judge will put the restrictions on the suspect, and then we will personally serve that suspect. And essentially, that order is good for 5 days, 5 court days, 5 calendar days. And then the idea would be that the victim of the crime would then seek out their own protective order through the court, and hopefully do it really quickly. And I know you have a lot of advocates on this call. I know you guys have helped people through that process, and it's really important that that they follow through on that process and get our the suspect served. But that is something that we are required to offer. And again, it's up to the individual to accept that offer or not.
Thank you so much for answering both of those.
Thank you.
Georgie, do you have a question?
Hi, yeah, thank you both so much for speaking on this matter. I just wanted to ask if there's anyone in this discussion or moving forward, if there was somebody who wanted to connect with either of you about these trainings or about learning more about this, what would be the best method of contact?
Yes, I can put my email in the chat and my phone number. So I'll just go ahead and do that after I'm done here today. And so anyone can contact me. We can arrange for that training. I know the DA also has training that they can provide, but I'll be available to answer questions or to provide additional training or follow up after this training here today.
And likewise, Georgie, if anyone wants to reach out, they can contact the coalition, and Linnell can forward that to me.
Wonderful, thank you both.
We have a couple of minutes, so I wanted to just jump in. We've talked a little bit about CLETS, and I just also wanted to see if you had any comments about the also tribal access to NCIC, because that's another access venue for tribes to register protection orders or to have information that can help them in both the issuance and the enforcement of protection orders.
Did want to mention there's also an additional comment on the chat. I'm not sure if it's a question, but maybe we could provide any type of response, if there's any response.
Yeah, so Danielle said that we have had to file order to show cause on several cases because they would not honor the restraining orders.
I'm assuming that the judge wouldn't grant the restraining order request. Is that what that means?
Can you hear me?
I can, Danielle. But I think you just went on mute again.
Can you hear me now?
Yes.
Okay, so what I'm talking about is we've had, so I've done, I work in the Hoopa, Yurok, and Humboldt County court systems. We've been pretty successful with getting granted all of our restraining orders, but on several cases we've had to file order to show cause or contempt of court because we called the officers and they were served and everything was through. You guys actually served them, but for some reason they could not find their restraining order in the thing, and we had copies of them. But they were, it's like the officer was the judge, jury, and prosecutioner of the case. So they made their own determination as to what they were going to do in that situation. And it's pretty scary because a lot of times our office hours are not we work around the clock with people. And so sometimes when the officer is like not going to honor it, then I'm stuck trying to figure out what to do with the client to keep her safe. And so we've, on several incidences like that, we've had to actually contact the Strong Hearted Women's Coalition and fly them out of the area so they didn't become MMIP cases. And so it's really vital that when the officer is there to take their order seriously, like if they feel like they're in danger, they should be arrested, like you said, in a perfect world, but it's not happening all the time. So I just wanted to bring that to your attention, that I'm boots on the ground. I work in the field, and yeah, we've seen it. And we actually filed cases through the court system with the order to show cause and got people in trouble for contempt of court with the judge and had them arrested because of that. So it's a lot more work, but we're willing to do it just to make sure that our women are safe. And we just want to make sure the officers know that they're not the judge, jury, and prosecutioner. Thank you.
Absolutely. I appreciate you bringing that up. If there's ever those issues in the future, please contact the watch commander, because sometimes the deputy does not have their facts correct, and they may think that they know the law, but sometimes they have to be reminded about that. And so a supervisor or watch commander can tell the deputy, no, we will take this. No, we will enforce this, and we will take enforcement action. And so that's very important. Again, this is something that that we can't look at emotionally or make a decision on this based upon anything other than the facts of the case. If a restraining order exists and the person has been served and violates the restraining order, we have to take action on it. It has to be documented action. So that's going to be very important that our deputies do that. And then these issues can get resolved within Superior Court or Tribal Court. And that is very necessary. And so that we are able to take that enforcement action.
Thank you, Sheriff. And thank you, Danielle, for that question. And I think it serves us as a wonderful transition. Our final segment for today's training is the Tribal Victim Services Provider representatives and panel. We have several representatives with us today. Thank you all for attending and for participating so far. But now we have some time on the agenda for you all to both present and or ask additional questions if you have them. So please feel free.
So my name is Danielle Vigil Maston. Hey, young Hamalio, Akweka Ante, Ahoye Danielle Vigil Maston. I'm the manager and advocate for the Office of DV, SA, and MMIP Prevention Program based out of Hoopa, California. Our service area that we provide for is the Hoopa Indian Reservation, which Peck Johnson's, Willow Creek, Salyer, Hoopa tribal members, if they live off the reservation, we provide limited services. And so it's a pretty large service area, but it's the same service area that the ambulance provides services to. So introduction of our program was established in 2019 as a new DV, domestic violence sexual assault program. And in 2020, we added the Missing and Murdered Indigenous Persons Service Program. And during COVID times, we served from 2019 to 2021, we served over 350 clients for domestic violence. To qualify for services, you must be in an IP relationship, intimate partner relationship. You must live on the live within the service area or be a Hoopa tribe member off the reservation, or a victim of family domestic violence or sexual assault. We also service all people that live in that area. So red, yellow, black, and white. So one thing that popped out to me is violence has never been a Native American tradition. So why our program was created was created to provide a non-judgmental, safe, confidential, culturally appropriate services for individuals that reside in Hoopa and the surrounding areas that are limited. We provide services for domestic violence, sexual assault, stalking, dating, and we offer support for victim survivors that are living in dangerous situations. So during COVID, this is from Humboldt County. Shows how high domestic violence was, according to the chart from Humboldt County. You can see like it's way off the chart compared to any of the other crimes during that time period. We are one of the only domestic violence MMIP programs that are boots on the ground in this area during that time period. And so that's why our numbers are really high. So what services are available? We do crisis intervention, safety planning, emergency services, transportation, relocation assistance and wraparound, assist with county court advocacy, support with legal services, and assistance with civil and criminal court processes, including obtaining and enforcing protection orders for the Hoopa, Yurok Tribal courts, and Humboldt County Superior Courts. We do referrals to community resources. We advocate and we give options for various services in the area, as well as assist with referrals to culturally appropriate shelter services that provide from a cultural perspective within the legal system in an effort to enhance existing services for protection. That's a mouthful, but we want to make sure that we have a lot of tribal people that come through our programs, and we want to make sure that they're not getting re-traumatized or victimized during this process. So we accompany them to the forensic exams, police interviews, educational prevention. We offer educational prevention training, community awareness project and outreach, cultural groups, and activities for holistic spaces. We have resource and women groups, which this is my favorite part. This is healing from the trauma that's just generational. We actually do grounding, which is reconnecting into Mother Earth for our groups to be able to offer healing from traumas. We talk about our domestic violence and sexual assault stories, and a positive holding space, which is natural, which is of the earth. And sometimes we don't even talk at all. We just go out, and it's a form of healing. It's just being together as one and connecting and being able to go out there. We do have a washer and dryer laundry service that we have here, and a clothing closet that we're able to assist people that in the community that are a victim of violence to be able to have that. We've provided with Katrina Sims here a sex trafficking training, and all of these individuals that attended are trained. We did facial activities with girls, and then we also went out and collected shells to make traditional regalia. So that was a part of the services that we provided. We also work with different spiritual advisors on healing from traumas. So we just came back from a training in Florida. These are the statistics that they pointed out to us, that 84.3% of Native American women have experienced violence. The one that's always missing here that we see a lot is the two-spirited, but they're kind of not really looked at that much, but it's a really high rate, which is 29.3%. Tribal jurisdiction over non-Indians of VAWA 2013 and VAWA now is, it gets really confusing fast for everybody. So I put up this chart so that you guys would be able to see the difference between what is in 13 and 22, which is shows that what's added in under criminal jurisdiction, since we're under a PL 280 states over non-Indians. This is really important so that you can take a look at it. Being an advocate, it's really confusing all the time as to what jurisdiction, as to where it happened and what type of crime and where it goes and what court it belongs in. So we often have to figure out how to navigate, and you can see this jurisdictional maze, which you can see like what court it belongs in for different types of crimes and different types of situations, and they may often vary, and some are not held accountable for crimes against Native women and children. It's really sad. So how does DVSA MMIP sex trafficking intersect? So as this was created by the Strong-Hearted Women's Coalition, they did this chart. So it shows sexual assault, murder, missing, stalking, and domestic violence and sex trafficking. As you can see, it's all connected. Many of our clients that we've been able to help, I've been in advocacy for over 20 years. And we noticed that a lot of our clients that we help, if the restraining orders are not held up, some of them end up missing because they're not enforced, because it's really scary. So this is a really important, I'm really glad that the court system is actually discussing it, because it's really, that's why we have MMIP cases, and a lot of the domestic violence sexual assault end up in MMIP. And so all the tribes across the nation are talking about it right now, and it's a huge deal. And so it's really important that the orders are being enforced, because many of them will not even get them. And that's where it gets scary, because they take crimes into their own hands. So we hold events and stuff to honor the missing and murdered. We have Hoopa, what is MMIP? Maine. MMIP was established in Canada to raise awareness of murdered Indigenous women throughout the organization. We're building our own database, and we work with Humboldt County to be able to have the missing murder page, and we work with them to update it to try to make sure that the information is correct on there. And they also have murdered cases. We've been working with an investigator from the Yurok tribe to be able to try to solve these cases. So 22% of MMIP are from the Hoopa Valley tribe, which is one of the highest rate in the state of California. 5,712 MMIP cases are urban. Indian Health Institute are gathered across the nation. This is not a true accurate number because a lot of the area up here in the northern is not included in this number. 34% of Native American women are sexually assaulted, which is 10 times higher than any other race. 90% of the sex trafficking crimes are committed by someone they knew or someone they knew personally. So that's really high for children being sex trafficked on the black market. You know, they have the black web, dark web. So 90% of sexual assault violence against women is done by someone that is non-native. So the services that we provide is we protect families and victims of crimes. We give educational activities. We help them relocate. We help them within the first 48 hours to contact the Humboldt County Sheriff's Office and to report the person missing. We also work with Hoopa Tribal Police and the Yurok Tribal Police if it's in that area to be able to assist them with posters or with social media to be able to find them. We were successful this year in finding, now our number is up to 10. We just found one on Friday. So we've been able to help families find missing and murdered, 3 of which were dead out of the 10, and the rest was alive. We were able to help the families with law enforcement to be able to solve those cases. So it's really exciting things, but at the same time, really sad. We provide educational prevention, training, community awareness, and outreach. We maximize services because they're limited. We work with other programs like the Hoopa Tribal Court, the DA's office, Humboldt Area Foundation, Northern Court Coalition, Strong Hearted Women's Coalition, the Karuk Tribe, DV program, and also Talawa and Trinidad Rancheria. Our program is not a first responder, so if you're in immediate danger, remember to call 911. We also offer relocation emergency supplies for clients that are in danger. We have a washer and dryer facility, showers, so if somebody needs a shower, we also provide that. We also provide tribal member assistance to our tribal members that are off the reservation if they are a victim of crime and are a missing person. Or a victim of domestic or sexual assault. We help them come back to the reservation if that's their choice, or we help them out wherever they are. We meet them where they're at. Safety planning, prevention, and educational transportation and events and rallies is what we assist with as well. So missing and murdered Indigenous persons, what do you do when someone goes missing? So this is what comes up all the time. So we created this little page to be able to help hand out so that people know what to do when somebody goes missing within the first 48 hours. And so you contact family, friends, coworkers, significant others, and ask them if you've heard anything from the missing person or seen them. Contact the local jails, hospital, homeless shelters, and the last place to call is the morgue. Call to check if there were any arrest, or check with the hospitals to see if they were admitted, check with the homeless shelters, and then also the domestic violence shelters, because one of our people were in the domestic violence shelter and it was really hard because they didn't release information, but at least you could share the photo with them. Contact your local police department, tribal police, or file a missing persons report with them. Have a recent photo of them and what they're wearing. Social network, check with their social media accounts, Facebook, Instagram, Twitter, etc. if they posted anything, and then contact your local MMIP program. So one thing that we started doing as a domestic violence program is we started taking photographs with our intake form. You can do your intake form off our Kamau Medical's page. So you can get the information and send it back into us, or you could come in and do the intake with us. We try to keep it short and sweet, so then that way we're not holding people up in that process. But one of the things we started doing is taking their photograph, because with their weight, height, and all of that, because if they have so many red flags, we want to be able to help them if they end up murdered or missing. And it's really sad, but that's the way that things are starting to turn out. So in the state of California, we have the most MMIP cases. I talked about that earlier. So according to Sovereign Body Institute, the Hoopa tribe has 22%, Yurok tribe has 16%, Round Valley has 11%, and the Creek tribe has 8%. So recently in the state of California, there was 3 declarations that was issued as a state of emergency, but the first one was by the Yurok tribe, the other was by Covelo or Round Valley, and then the other tribe that entered into it was another tribe from Central California. So I know I'm talking fast and that's a lot of information to get through, but I know the time is short. So our office hours are flexible, but we are usually always here from 10 to 5 p.m. If we are not here, we're available for appointment for emergencies. Our new shelter, our new program office, it's really exciting. We just moved into our new building and we have a gated gate all the way around, and we have cameras, security cameras and stuff to be able to assist clients to make them feel more safe. So I mentioned earlier that we're located at Kamel Medical Center, and we are adjacent to the MAP program, and we're able to do referral services through behavioral health, which is we can do mental health services, and then we also could do drug and alcohol, substance abuse referrals through that program, also medical, because we're located here on the medical facility. So we're able to do the referrals on site and be able to get the clients the help that they need to be able to meet those areas. There's so many more areas that we want to cover and go after, so many more grants that are not covered under our service area, under the DOJ grants that we have. But we're just starting out and we're trying to build as we go. And build and learn, we're always growing. So we're going to be hiring 2 new advocates with our program, and we're short staff and just trying to build as we go and navigate the system and be able to, we're also going to be hiring an attorney. So we'll have our own attorney on site. So that's pretty exciting for our program. They'll be able to help, the attorney will be able to help with cases that are really hard to navigate through, because sometimes the abuser hires an attorney and fights the domestic restraining orders. And sometimes we have clients that come in here that were the victim and then the person beat them to the court and filed the restraining order. And then we have to help them with those types of situations. So any note, that's our program in a nutshell. There's these are the MMIP programs that we found that been helpful to help us in these type of cases, and we thank you for your time and energy on this call. If you have any, let me know.
Well, thank you, Danielle. That was great information. I'm sure very helpful. And yeah, our time is running short, but I know that Kate had spoken with Vicki Bates as having some information to present. So Vicki, go ahead.
Sorry. Yes, I'm Vicki Bates. Can you hear me?
Yes, we can.
Great. Danielle's presentation was beautiful. I cannot match that. So I'm just going to talk a bit. We do a lot of the same things that Danielle does, kind of the same programs and stuff. We just started working on the I just started working on the MMIP about a year now. I've done a couple of searches with a group that had cadavers and with the local police force and the sheriff's office in Crescent City, looking for somebody in our tribe that was missing. We didn't find the person, or we found some tracks, maybe some ideas to follow up on. We're very busy here. I got 1 staff that works with me. And of course, like Danielle has said, it's not 8 to 5, but we work 8 to 5. So it ends up being around the clock. I usually do accept text messages and things from clients during the weekends and the evenings, but sometimes things just come up. We just helped somebody with a couple of trafficking situations in the last couple of weeks. That was very interesting and kind of reaching out to other resources to work with. We worked with the International Resource Center, which were great people. We have a girl that works up here in Crescent City, a lady, her name's Haley, and she's helped us out tremendous. And she had her supervisor come in from Sacramento, Vanessa, And then we had a training from their supervisor that came in, John, who came around to different areas and trained some people on the trafficking situations. All of this stuff all ties together, just like Danielle was saying, and showed her chart of everything going together, domestic violence, sexual assault, trafficking, MMIP. And I want to add in the mental disorder. Most of it, I believe, stems from some type of a mental disorder that happened. And I'm working on trying to get mental health. We've been trying to get mental health, working with the tribe here for a long time, trying to pull in somebody. It just seems to be so hard to get people to come to these small areas and work with us. I'm working on the mental health program in Crescent City to try and work with them and collaborate with them to work together to try and figure out how we can get services for people that aren't really requesting services and don't realize they need it, is kind of where I'm stuck at with people that I've been working with. So I'm trying to find out with mental health what we can do for those people. I've gone to courts and stuff with people, and it still hasn't stemmed out to the right way where the person reaches out and asks for assistance. So that's another hurdle we'll go over, and we're going to smooth through that. I'm positive thinking on that. And my number here at the Yurok Tribal office, you can call the main number and get in touch with me at 707-482-1350, extension 1344. We were housed in the Justice Center and we had a leak in our roof, so we had to move over into the main office, the headquarters. So I can put my information into the chat. You can also look up Yurok Tribal Courts, and find my information on the web. And that's about all I got. Thank you very much.
Thank you, Vicki. Our time is running very tight, but I do want to make sure that I provide an opportunity for anyone else who would like to talk about their program or the resources that they have.
Hi, I'd like to talk really quickly about the California Indian Legal Services Legal Access for Victims program. Sierra, who's on the call, is my DV advocate, but for our program, unlike what Danielle and Vicki are able to provide, we can't do anything but assist people with legal questions. So if someone if they want to know what their options are, if they want to talk about which jurisdiction to file in, if they know they want to file and they need help with paperwork or prepping for hearing, they can contact us and we can assist with those details. If someone, we see people oftentimes who need supportive services like laundry, transportation, housing, those we need to refer out to other programs because we don't have the funding for it. So when our clients do come in with those needs, Sierra researches which programs are available to meet their needs based on eligibility requirements. For our program, we can assist people who've experienced domestic violence, dating violence, sexual assault, or stalking. We can assist people who are over the age of 12. If it's 12 and under, the grantors have determined that that's actually a child abuse issue rather than domestic violence, even if it is a sexual assault type issue. And that's pretty much our very brief rundown. I will put our contact information in the chat because I cannot remember our phone number off the top of my head because I don't call it. Thanks a lot. And Sierra, if you had anything to add, please feel free to jump in.
I'm sorry, I just put my contact information as well, and I had to look up our phone number as well, so not just you, Michelle.
Yes, I just added the CILS contact information in the chat.
Excellent. Thank you, everyone, for your participation and attention. It is greatly appreciated. Just a few closing comments. The Northern California Tribal Court Coalition has some resources available on our website as well. And our job, as well as in part of the coalition, is to identify and fill gaps in between the programs and resources that are available in the region. And so we have some self-help resources. We have some code draft provisions that might help tribal communities. And we also have our self-help app that we have been promoting and have information for. You can find that information on our website. And again, thank you so much for your time and attention. It has been, I think, hopefully very informative and helpful to you all. And if you have any further needs or questions, you feel free to contact the office at the information provided. Also, Mary Kate, our wonderful project specialist, as well as Georgie, and we are all available if you have need. So thank you.